What's up, ladies and gentlemen? It's the Resistance. Back at y'all with another live stream. This is part two of the pre-trial audio hearings, the Resistance versus the Commonwealth of Massachusetts. This is a continuation from earlier today. If you guys haven't seen it, make sure y'all go back and check out part one. It was basically all the audio hearings for pre-trial, all the hearings that we had before trial. Shout outs to Rhonda, Right to Freedom Girl. Appreciate y'all. Clayton Nelson, what's going on? Yeah, so we continuing this thing late in the evening. We'll finish up, wrap up the last hearing that we was in, and it was motions to dismiss certain charges. Well, actually, we tried to get all the charges dismissed, which was on April 14th, 2022, and we were only able to get the charge of intimidation dismissed. If you guys heard the recording earlier, I was explaining how the judge was basically bootlicking off the bubblegum narrative that Scott Roby had written. Shout outs to the Queen, Renetta Williams, all the way from Wynne, Arkansas. The gang's all here. Shout outs to everybody. I appreciate y'all. Let's get into it. But before we do, I know some of y'all probably wasn't in the live stream earlier. So just to let you know where we are in the federal case, Scott Roby has responded to the complaint. There has been an order written. Here's his response right here. This is his response, and he basically denied all the allegations that were criminal on his behalf. He admitted to certain things that he attempted to arrest me, and I was standing on the street. He admitted to those things, but when it came down to the nitty gritty of me being violated, my civil rights being violated, and being assaulted and battered, which they flipped on me and charged me with assault and battery on the cop. But all those things that were clear in the video, he basically denied. And this is his answer right here. This is his answer. And seems to be that the judge did not give a fuck because he went on and went with his order. The order says basically, ladies and gentlemen, is that we're in the initial disclosure stage. An initial disclosure stage, and that's basically both parties providing evidence to each other before the courts request a discovery. So things like, number one, names, addresses, and telephone numbers of persons likely to have relevant discoverable information in a copy, or description of all relevant documents, data compilations, intangible items in the party's possession, custody or control, a damages computation, and any relevant insurance agreements. And that's cool because I've been talking to y'all guys a lot lately about surety bonds, and that every officer has to have one to be a police officer in whatever state or county that they're in. They have to be insured. So because this is a civil rights violation, and unbeknownst to me, I didn't know that they were going to ask for this or request for the other party to provide this information. Any relevant insurance agreement, number 4, right here. So, got a couple people in my ear saying that they won't provide that information because, that's basically the information that's going to crack Roby's bank. So I still got to do legwork regardless. If they don't give it, I'm still requesting it, and I'm keeping a sharp documentation of it. All right. Shout out to everybody in the chat. BX Trust, the Django ATX. I know I'm supposed to call you, bro. I'm just a busy man. You got to forgive me. We going to connect, though. All right. We're going to get into the continuation of earlier today. And it's basically us trying to get these charges dropped back in April 14th, trying to get them dismissed back in April 14th, 2022. So let's listen.
Your motion to dismiss regarding the video?
I do. I have a motion to dismiss Commonwealth versus Odell. In this particular case, Mr. McCulloch was on the sidewalk. he had a system, not only his own personal phone, but it was hooked up to something that he could put on a handle and film. And he was out that evening filming different areas of the city when he came across the officer in a motor vehicle traffic stop on Blue Hill Ave. And he filmed the interaction between the officer and the individuals when the car was pulled over. And then when the car went to leave, when the officers were through, he approached the car and he was videoing. And the officers also had their body-worn camera on. There was 2 officers in the marked police car, and each of those officers had their body-worn camera on. I have Mr. McCulloch participates in a YouTube series, and he posts these videos on YouTube. So I have a copy of the video that he has, and that video reflects that Mr. McCulloch was on the sidewalk and did respond to the police request that he go back to the sidewalk. The request by the police were rapid. They weren't giving him time to go back to the sidewalk. They started yelling at him after the motor vehicle stop to get away from the car. Police officer approached the car, asked the car to leave, and told the car that it could leave, and continued to ask Mr. McCulloch to stay on the sidewalk. Mr. McCulloch asked for their badge numbers, and at that point, the police officer approached him and said, I'm not putting up with this anymore, I'm arresting you. And it's on video. The disorderly portion clearly, and from the perspective of the officer's body-worn camera and the perspective of Mr. McCulloch's video, I believe you can see that he is not resisting arrest. The assault and battery police officer charge, that is something that is hard to tell, I think, because the police officers at that point have their hands on Mr. McCulloch and are making the arrest. And when the arrest is already in place, Mr. McCulloch is screaming that he's been sprayed with something. And it says in the police report that the officer had his OC spray in his hand and it was discharged at that point. And I suggest to the court that observing this video that was available to the police at the time of the clerk magistrate's hearing, and that they had Mr. McCulloch's phone so that they could secure the video that he had taken, was available to them to present to the clerk magistrate, and that they failed to do that. And I think that the evidence is so exculpatory that it rises to the level of a dismissal of the charges if viewed by the court. That certainly the disorderly charge and the resistance.
I'm gonna stop it right there real quick. That's my public defender attorney, Joan Curran. She was representing me, and she's basically arguing. Well, her argument is that there's video evidence. There's video evidence from the resistance. There's video evidence from the police officers, and it's so exculpatory that it rises to the level of dismissal. And exculpatory basically means that it's showing clear facts that I didn't do anything that rose to the level of a crime.
Resisting arrest charge, and I would suggest also that the assault and battery charge should never have issued based upon that evidence. So I would ask the court to consider taking the videos. I have the YouTube video, and I think between myself and the Commonwealth, we could submit the body-worn camera video and ask the court to look at that and consider whether that evidence is such a nature that it should be considered in whether this case the complaint should have issued.
Was there any obligation of the police obligated to present the video to the clerk magistrate for seeking the complaint?
Well, I think the idea is when they know that the video contradicts the police report, I think there is an obligation, because there's clearly exculpatory materials or evidence in that video.
So this video was made public maybe about a year ago. I didn't make the video public right away. I should have made the video public right away, but I didn't. I waited for about a year to make the video public once these hearings started picking up. So basically, the judge right now is saying that, well, the courts or the magistrate didn't have any knowledge of the video. Well, the police officers knew that I was recording with a phone, and they took that device. They also broke it, and they knew that whatever footage that I was getting was in that phone. And trying to make it seem like, well, we had no idea that there was video evidence on the resistance part. But here's the thing. It was public by this time on April 14th, 2022. It was made public, and they knew about this. What they didn't want to happen is the prosecution wanted to dismiss, wanted to get it out of there, wanted to suppress my video evidence, my exculpatory evidence, which never happened. But they tried to do that, and they didn't want it to get in because they knew it was damning. They knew it was very telling.
That showed that Mr. McCulloch is on the sidewalk when it asked, to stay on the sidewalk, that he's asked for his badge number, and that was when the police officer says, "I'm going to arrest you. I'm not putting up with this anymore." And that you can see in the video that Mr. McCulloch's arms are straight down, and that in one hand he has the phone, and in the other hand it's obvious his hand is straight away, and they're taking the handcuffs and putting him in handcuffs, and at that point he's in handcuffs, he's arrested, he can no longer be charged with resisting arrest, and he's saying, "I've been sprayed." So at that point, I believe that you would be left with the determination that there's not probable cause for an assault and battery, given the view of that incident. Mr. McCulloch is screaming for his phone because he was concerned that the video would be destroyed in his phone. And that is comes out in the video as to why the police, I think at that point, gave him back his phone. He keeps yelling, "I want my phone, I want my phone." The court was interested in why they would be giving him property because he was so concerned about his phone. But I think in the video you can hear noise where the police are stepping on the phone, and that the phone appears to be destroyed. But in effect, because I guess of the streaming nature of the video, he was able to save it. Although I have a picture of the phone was actually destroyed.
Why? If this happened on April 25th, what happened and how come and he was arrested? Why wasn't he arraigned until May 13th? And why didn't the complaint issue until May 27th? I don't see a calendar up here.
I believe it was because of the COVID pandemic, Your Honor, based on the.
So that's what they blamed it on, the COVID pandemic. Actually, the arraignment was supposed to have been, let me see, April 2022. The arraignment was supposed to be in 2021, which never happened. But of course, they used the COVID pandemic as a reason. And it's all sloppy on the paperwork. I had the docket sheet in front of my face. And, it really isn't a date for arraignment.
On Wall's file.
Oh, it's just 2020. I see. I got it. All right. I'm thinking it was this year. All right.
And that's part of what, Mr. McCulloch out there filming. I think it was also, at the beginning of the pandemic when there was a lot of issues with the Black Lives community, that he decided that he was going to go out and be somebody who reported interactions between police and civilians, seeking to have police accountability in the community. I can submit the video and just ask the court if it would consider maybe taking it under advisement. I get the other video to you. if you think it's of that nature.
Well, I mean, isn't that really a decision for, ultimately for the fact finder to determine what's in the video as opposed to me doing it in a motion to dismiss? I mean, shouldn't that be for,
I think this is the first time I've ever done one of these, to be honest with you. The Odell motion, as we go along doing these cases, as the defense counsel, and I think also as a prosecutor, is we're seeing more and more video. And the video is having an effect on how we present our cases and saying, is this really a case that necessarily has to go to trial when the video is so clear?
and this is this body cam video or is this Mr. McCullough's video?
It could be both. All I have right now on a CD is Mr. McCullough's YouTube video from his direction, but could also submit the body worn camera video.
So how were the police department, how were the police officers supposed to have that video?
They had
To
his phone.
present-
I mean, they arrested him.
Did they have access to the video on his phone? I mean, our phones are protected in so many ways, and there are passwords and biometrics that are needed to kind of get into a phone. How is it that these officers, and if they went into his phone, I mean, they can't even search his phone without a search warrant, right? They didn't have a right to go into his phone without a warrant. So how could they have gotten the video in time for the clerk magistrate hearing, which was?
Well, I don't
Looks
know if
like-
Odell is limited to the
So
the
they
issuance of the complaint.
so they're trying to say that from Officer Roby's body cam, when the magistrate looked at the footage of Officer Roby's body cam, it will cause. But any way you look at it, whether it's Officer Roby's video, whether it's my video, whether it's the assisting arresting officer's video, it shows that I did nothing that rose to the level of a crime. So to be honest with you, the magistrate who determined the probable cause should be he should be getting some paperwork as well. Let's just say.
Odell is something that I can bring up during the pendency of the case to show that there's exculpatory evidence that should be considered by the court.
But Odell was it was his presentation to the grand jury, right? Was it and the officers or the Commonwealth had knowledge and access to exculpatory evidence. In this instance, do they really have access to this video that you want me to look at? Because
Well, I guess their body camera would be the same, it'd just be.
well, do you have the body camera video? And what does the body camera video show?
The body camera video shows Mr. McCullough on the sidewalk. It shows Mr. McCullough approaching the motor vehicle and how he is on the street. It shows whether there's traffic in the area. It shows that the stop is over and that there's no interaction with the individuals in the car afterwards to consider whether they were in fear or if they didn't want Mr. McCullough approaching, those types of things.
All right.
I mean, in my opinion, I can't see how the video wasn't able to get in or wouldn't been able to have gotten in, even without Joan Curran's argument. I mean, that's my defense. It's my whole defense. If I'm screaming video, and that's part of my defense, it has to be allowed in. If not, it's grounds for appeal. But good job on Joan Curran's part with her argument and fighting for getting that video in, because even though the judge, and this is Judge Keys, every hearing was a different judge. This is Judge Keys, and even though he was bootlicking all the way from the buttermilk narrative that Scott Roby wrote, it didn't seem like he was kind of, trying to, give up a fight for not letting the my footage in. So, shout outs to Joan Curran for, standing strong on her own too and getting that footage in.
I'm not set on taking the video just yet. I'm here from Lady Granatino.
Thank you, Your Honor. Nicole Granatino again for the Commonwealth. Your Honor, to start, I would just ask if there's
Prosecuting attorney Nicole Granatino.
a signed affidavit to support this motion to dismiss. Commonwealth did not receive one. However, I still am prepared to go forward. Your Honor, I ask that you deny my sister's motion to dismiss to an exculpatory video. Your Honor, I would suggest looking at Chapter 2, 18 of Mass General Law, Section 35A. When an individual, if a complaint is received by a district court or justice, assistant clerk, if not under arrest for the offense, which it is, the complaint is made, then a defendant would be given an opportunity to be heard personally or by defense counsel. I would just contend to Your Honor that the defendant was arrested at the scene, so I would suggest that he was not entitled to a clerk magistrate's hearing in this case, Your Honor. As to my sister's point, that exculpatory evidence was not brought forward in a clerk magistrate's hearing by the officer. I would highlight, as Your Honor just did under Odell, that the officers did not have knowledge of that exculpatory video as they did in the grand jury investigation.
Nicole Granatino, she's the one right now who you're here talking that's trying to get this video up out the whole situation. She doesn't want it to be played. She wants it to be played from Scott Roby's narrative and from his body cam footage because they're able to begin and end it where they want to.
Investigation in Odell, and I would suggest to Your Honor that the facts in this case are different in that the officer didn't know necessarily, one, what was on that video that the defendant had, and two, that probably from his point of view, he didn't think it was exculpatory given the situation and what had happened and transpired during the discussion.
So he didn't think that it would be exculpatory when I recorded it all the way from when he handed the driver back her documents all the way up until the point of arrest and when they took the phone out my hand. So that's clear-cut evidence from the beginning that I did nothing that rose to the level of crime. But prosecution is arguing that he had no idea that the evidence was exculpatory.
Conduct.
He had every idea that the evidence was exculpatory. That's why she's not trying to let it in.
But they didn't have knowledge of what was on the body cam video.
That is
Or
correct.
they should have known.
That is correct, Your Honor, and my apologies, I don't have case law. I don't know what an officer's duty at that point, given body camera footage is so new. I don't know what their duty would be.
Is there a duty, I guess, is the question. I'm not sure that there is a duty at this point.
I don't believe there is, Your Honor. I think, when issuing a complaint, you look at the four corners of the police report. I'm not sure if they have a duty to present body camera footage. I think that'd be an extra step that I candidly have not heard of ever been having taken. And for those reasons, I would ask that you deny my sister's motion to dismiss based on the exculpatory video.
So that's their argument right there, prosecution, on trying to get the exculpatory evidence dismissed, which is a goddamn shame. I'm gonna take a break real quick. I want to give a shout out to everybody that's in the chat. I also would like for y'all to hit that like button, share, you know what I'm saying? Get this out here because you're listening to a man who is not going to buckle, okay? I'm going to take it all the way to the end. I ain't got time to be playing no games. If you want to see how it's done, then this is where you tune in and you hear the factual evidence and you'll hear the quietness of a man who stood still and didn't budge and looked straight at the judge. It's the resistance, man. Shout outs to Mom's Wholesome Videos, Jack Off Jack, Baba Babel, BX Trucks. Gang's all here. Make sure y'all get this out here, man. This is on y'all. Share it, like it, subscribe. It's the resistance. Y'all know what I do. I've done it for over 2.5 years. Everything's on a slight decline right now, but I'm always bring y'all the facts, all right?
I'm just a picture in the frame. Pause. I paint word pictures on the canvas of life.
I'm everywhere in public. Right to freedom, girl. Strictly business. Appreciate all of y'all. Rico Baca. The Queen, Renetta Williams, all the way from Wynn, Arkansas. Bill O'Wright, 1791. Django ATX. That's my man, the Django ATX. Clayton Nelson, Rhonda. We're going to get back into it, y'all.
here.
So he's arrested by the police. They just they file the application for complaint to the clerk magistrate. If they have to present the video here, then they would have to do that every time, right? And to the clerk magistrate before the clerk magistrate issues any complaint. And that could overburden the clerk magistrate's office with all the complaints that come in and everything now where all the police officers are wearing body cameras, and their videos available is there. To make it a requirement that they submit the body camera video, I think would be overburdensome. Every time, because that's basically, that would have to be the case, right? If I do it here, then every time somebody's charged with a crime, the body camera video would have to be submitted to the clerk magistrate.
Well, I'm not necessarily saying that it has to be submitted, but as I think the court has pointed out, this police report has been artfully drafted or has been significantly omitted sections of it in terms of putting the police report before the clerk magistrate to support those charges. So there are things that I believe that the video shows that should have been included in the police report. We're not always saying that in every police report that the video would have shown exculpatory information that the police officer was aware of. For instance, that Mr. McCulloch was on the sidewalk, that Mr. McCulloch wasn't acting in that disorderly manner when the police officer decided to arrest him, that Mr. McCulloch had his arms down by his side during the process of the arrest. He may not have been participating in the arrest procedure, but he stood there and had his arms down by his side. So it's in this particular case that I'm stating that because the police report omits significant exculpatory portions, that I'm asking the court to consider looking at the video.
I just think I think it's an issue for the fact finder to determine at this point. And for me to look at it, then I have to put I'm substituting my belief or putting my judgment in I'm making it my judgment as opposed to what the whole process here is about, which is the jury is supposed to make that call. So I'm not going to look at the video. I don't think that they had the obligation to present the video to the clerk magistrate. I think that's a trial issue, and if you want to show it to a jury and say, "Hey, look, this is inconsistent with what's in the what the police officer said," that's what the trials are for. So I'm going to deny the motion for to dismiss. And then I have here a motion for discovery.
I do have a discovery motion. If we can just go through it. In this case,
Well, hold on. Agent Benatino, have you seen the motion?
I have, thank you, Your Honor.
Is there anything on this motion of the 11 things that are on here? Is there anything that you agree to?
Your Honor, I would agree to one, list of Commonwealth witnesses and dates of birth, as well as number 7, including Ms. Maldonado's address and date of birth as she was present at the scene. I would also agree to the names, number 4, names and badge numbers of all police officers present during the alleged incident and booking process. And that is it, Your Honor. I would just highlight number 2, citation number. Typically, from my understanding, citations are just given to the defendant. I don't know if the Boston Police Department would have a copy of that citation. So I just would highlight as number 2, that being what specifically you're looking for.
Okay, so let's start with number 2. Is that the citation given to Ms. Maldonado?
it is.
So how would that be relevant to the charges against Mr. McCulloch?
I I was looking for the citation to get information as to Ms. Maldonado. I think we can agree that a warning was issued. I'm fine without the citation at this point.
Okay, because the information that you wanted from the citation, you can get from number 7, which the Commonwealth is agreeing to give to you.
Say again?
The information that you want about Ms. Maldonado,
Yes.
you're going to get from number 7, which the Commonwealth is agreeing to. Okay. FIO reports,
Right, if
Mr.
there's any
McCullough?
investigation reports for John McCullough, my understanding is that, there have been, prior incidences between this officer and Mr. McCullough. And if there's anything that the Commonwealth may have, I think I'm entitled to it. To show any
So
kind
it
of,
potentially could show a bias towards Mr. McCullough if there are FIO reports.
Certainly, Your Honor, and the Commonwealth, that is not within the care, custody, and control of the Commonwealth. Commonwealth has nothing to do with BPD Legal's reports. I would suggest my sister files Rule 17 to obtain those documents. I do not have those documents.
is this just on number 3 on the FIO?
That is
This is
correct.
number 3, yeah. You're saying that you don't have access because they're in the possession of the Boston Police Department?
I do
who
not
prepared
have-
the reports that you use and give you the body camera videos that you use and give you the ballistic reports that you use and the fingerprint reports that you use when you go to trial. You're saying that you can't get the FIO reports from the Boston Police Department?
I would suggest that a Rule 17 would probably be the better way to go through it. I think that that's putting a burden on the Commonwealth, getting those reports.
It's just a matter of calling the Boston Police Department and saying, hey, can you give us the FIO reports? It's not, there's no national security issues relating to these FIO reports as far as I understand, right?
Apologies, Your Honor, I was misstating it. I thought this was the one for Officer Roby. Or,
No, we're not talking about internal affairs reports. We're talking about field
The defendant,
investigative reports
no
relating
objection.
to Mr. McDonough. Okay.
I am,
McCullough, excuse me, so.
I'm very sorry. I misread that.
So your Commonwealth
Hold on.
agrees with number 3.
Yes.
It's McCullough?
McCullough.
McCullough.
Yeah, they fucked my name up throughout the whole trial. It was so many pronunciations in Gaelic. It was just crazy.
Right. So Commonwealth agrees to number 3. Okay. So number 4, you agree, it's agreed upon. Number 5,
Number 5 is the
Oh.
civilian complaints and disciplinary reports, and I think that is usually Rule 17, right?
yes.
Okay.
And
Uh,
my apologies.
Do that by Rule 17.
And I would just also object, citing that is an overbroad request, all prior civilian complaints and
Well, she's
disciplinary
withdrawing it,
reports.
so we don't need
Thank
to. Yeah. Number 6,
I'm interested in prior assault and battery charges that were brought out by Officer Roby against defendants. If he has a significantly high number of those, and I phrased it that way, complaint numbers for all prior assault and battery. Because I think that whenever an officer charges someone with assault and battery on a police officer, that they have to submit a certain form internally. So I would like to see something along those lines. I think
Okay.
it's,
Again, Your Honor, Commonwealth would object. I would suggest that all prior reports filed by Officer Roby regarding ABPOs is overbroad. And I would suggest,
So, him just going hands-on on me is not enough to go into his background of other arrests. Like, just totally ignoring the fact that this dude went super berserker, put his grubby paws on me, demanded for me to put my hands behind my back without a crime being committed. Of course we need to go and check his background.
that, again, that is overbroad and should be not allowed.
I just think that there's a way to
So-
supervise that with the BPD.
And candidly, I don't know how even the Commonwealth would go about doing that. I don't know if there is even a way that the Commonwealth would be able to just search Officer Roby's name and charge number. I think that's just overbroad, and candidly, I don't know if I have the capability of obtaining that information.
No, I'm also, like, is it situations where Mr. Roby is the alleged victim of the assault and battery on a police officer charge, or where he files the charge and it involves other officers as well?
So just him.
And is it situations where he files it on his own behalf versus someone else filing one where he's the victim, the alleged victim of the assault and battery charge?
Wait, he's the victim.
It's so crazy that they're even speaking about a police officer being a victim, because a police officer cannot be a victim, especially in Officer Roby's situation, in his case, because he's the one who initiated the whole situation. Okay, because he didn't like me being in the street. That's when he went hands-on. Now he wants to cry victim. He's a police officer. No victim.
So it's where you're asking for all prior assault and battery on a police officer charges where Officer Scott Roby is the victim, the alleged victim in that charge. So how would that be determined? And is it, and what's the relevance of those potential charges to Mr. McCullough's case?
I think I can look at them and see if I can form a pattern, and see if there's some history here of certain types of complaints resulting in assault and battery on police officer charges without injuries on multiple occasions, or with minor injuries. I think it's a basis for cross-examination. I can limit it to less than 5 years to 3 years, but
Again, I don't know how the Commonwealth would even be able to obtain that. I wish there was a way I could check off Officer Roby's name and check off ABPO, but unfortunately, I candidly don't know how I would even go about getting those documentations.
I think we can ask them. Just
Really what you're asking is that it would require a search of the court dockets, right, to determine, because you're looking for the complaint numbers, which you're only given out by the clerk's office. And the clerk's office would then have to do a search of all assault and battery on a police officer charges where Scott Roby is the victim.
Well, this is my understanding, right, that when a police officer is the victim of an assault and battery on a police officer, there's a certain form that's filed within the police department that they have to submit that they've been a victim themselves. I don't know the exact number of the form, whether it's a form 12 or what exactly they call it, that they would keep an ongoing list. It may not necessarily be by complaint number, but there would be some kind of indication of how many assault and battery charges this particular officer has been the victim of in the last 3 years.
Well, wouldn't that be then a Rule 17 motion to
I could
the,
do that, have it incorporated in that.
okay.
I'm okay with that.
7, the Commonwealth is
7 to
agreeing
read
to.
to. Number 8, the paramedic EMT reports, that's just for this case, okay?
Right, Mr. Roby is alleged to have been injured. If he was seen by EMTs or paramedics, I think that could be relevant information.
Yeah, we're under Rule 17.
But it's an EMT, so if you, so is there any indication that he was seen by a paramedic or had any medical?
There's no indication in the police report.
So it could be that he just got to put a Band-Aid on his finger when he got back to the station.
It could be, but I just want to avoid asking the question and say, oh, yes, I was treated, you know, at the health center in Cambridge, or to give me some kind of information if in fact there was any kind of treatment.
So right now, it's just it's speculation as to whether or not there even are any records, any EMT records or paramedic records, right?
Unless the Commonwealth tells me right now there's no treatment, then I'm fine with that, as long as I think that's a question that
The police report does read that Boston EMS was called, and I believe they did evaluate the defendant. But I don't believe that the officer was
The
evaluated.
suspect was checked by EMS and refused attention. Sergeant Brooks photographed the officer's injuries.
yeah, and I don't have the photograph.
So that should be something that the Commonwealth should be turning over if the photograph exists. I mean, it does exist because it says that they took the photo, so that should be evidence that should be Rule 14 evidence.
That's right.
So right now, I don't have any basis to believe that Officer Roby was seen by EMTs or paramedics. I'm not going to order the Commonwealth to turn it over. And if that were the case, it would be a Rule 17 motion anyway, to get it from the EMT records. So I would deny number 8.
Okay. Number 9. My understanding is there's been prior interactions between Officer Roby, as I said, and the defendant, John McCullough. I think there's been
That resulted in criminal complaints?
no, I don't believe so. I just
And does Mr. McCullough know the dates when those interactions were? Because that would be helpful in making the determination as to kind of narrowing.
By who? Okay, but did we or you? Okay.
So that's me talking in the background, instructing her, informing her that, there has been initial engagement between Roby and I in the past video that most of you guys probably have seen. But he was saying the same thing in that video, saying, if you don't get out the street, I'm going to lock you up, which was the unlawful command that he gave me that night.
I think I can get dates on that, and I could include it in the Rule 17, because if it's, I'll do it.
Okay. So what I was going to deny number 9 without prejudice to you, because I think you need more information, and I think that can be more narrowly tailored.
Number 10 is that form I'm referring to specifically
No, that's
in this case.
yeah.
So in this case, it's like the EMT. Say, how do you know that there is a form? I just have seen when I have cases with assault, battery, and a police officer, the last line is the police officer submitted form, and I don't know the number, but injuries associated with the incident.
And
So
I think,
they have to submit something if they have injuries.
right. So I think in terms of this case, as it relates to this case, if there's a form that's filled out and it's an injury form that the officer is required to fill out, I think it should be turned over. I don't think that should be the subject of a Rule 17 motion, because that's directly related to this case.
Your Honor, Commonwealth would object. There's nothing in this report that suggests any sort of internal police form was filed. I understand that my sister's seen it in the past, listed specifically in the narrative as she just stated. I don't see that here. Candidly, I'm not aware of any such form, and I would object.
If it were just any form, I would agree with the Commonwealth on that. But where it's relating to the injuries in this case, And I don't think of it as a fishing expedition. I think it's something that the Commonwealth should be turning over, because it's a documentation of the injury that this officer alleges that he suffered as a result of his interaction with Mr. McCullough. So I am going to order number 10.
If it exists, Your Honor.
And if you,
Oh yeah, obviously if it exists. If it doesn't exist, then
let me know.
yeah, let her know. But I am going to order that it be done, that it be turned over.
And if there's any supplemental reports, any internal reports, any follow-up reports, any other police reports through the 126s?
Again, I would object. I don't, to any supplemental reports for an assault and battery on a police officer charge. Is that just in general? Is that related to this one specific incident? Is it related to all assault and battery cases?
And I think number 11 is it pertains to this case, that's automatic discovery that the Commonwealth would have to turn over. And I think there's an obligation on the Commonwealth to at least inquire as to the existence of other reports.
Thank you.
Right, so endorse this.
And if I could just clarify, that's just to the supplemental reports. I'm not sure what my sister wants, meaning, quote, any internal reports.
It'd be kind of similar to the number 10.
Right.
Just pertaining to this particular case. I'm gonna endorse this motion. I think kind of hopefully clarifying it, and I'll explain it to the parties when I'm done endorsing it. Okay.
Thank you.
Shout outs to Mark Wunderlich. He was in the live stream earlier, and he had asked a question. He said, did the prosecution call your public defender my sister? And I spoke on that last time on the last stream, and I said, yeah, I said they refer to each other as their sister or their brother. And I'm talking about the prosecution and the defense attorneys, the public defenders, and even the hired attorneys. That's how they converse with each other in court. And it's just like, when you really look at it, it really shows the unity that they have with each other. And basically playing a game with you. So it's basically, all right, it's like a Battleship, they're going to strike, you're going to strike. Well, speaking of your public defender, and it's all a game to them, but, it's basically everything is on your shoulders. And, I thought about that. Shout outs to Mark Wunderlich. I thought about that, and I said, it's deeper than what we actually hear. They are, they're connected. They work with. I'm convinced that they work with each other. I don't care what nobody says, even though I would give, a good amount of credit to my public defender for, fighting on my behalf. They're connected and they work with each other. So shout outs to Mark Wunderlich for mentioning that. Yes, they do refer to each other as their brother and sister, their brother-in-law and their sister-in-law under the court of law. Because what? The first duty is to the court. The second is to the people. And the people is the people. The common law that they have set. And then it's to the client. So basically, you're asked out either way. You just got to fight hard and stand your ground.
All right, so I've endorsed it as follows. The Commonwealth agrees to numbers 1, 3, 4, and 7. The defendant withdraws numbers 2, 5, and 6. As to count 8, that request is denied. As to request number 9, as to request number 8, that is denied. As to request number 9, That's denied without prejudice to the defendant. Commonwealth is ordered to inquire and produce, if they exist, documents responsive to numbers 10 and 11 that are in the care, custody, and control of the Boston Police that relate to count 2, the assault and battery on a police officer charge, in this complaint.
Okay, Your Honor. I just make it clear that on 2, 5, and 6, I can seek those through Rule 17.
But yeah, I just because it was a part of this motion to produce. I anticipate you're going to file. I'm not saying that.
No, I get it. What
Yeah.
we're saying that then legal comes in from downtown and they say, she would do that request.
No, you only withdrew it in terms of this motion, but you're able to file a motion for discovery later on down the road.
I had a few other things. I don't think the clerk has to read that out, does he?
No, it's endorsed. You can. I read it into the record, and it's endorsed. So you can.
I have a few quick issues, because Mr. McCullough was arrested on this. He made a cash bail of $400. I believe was the first case on his record. He has a couple of cases similar where he's video recording the police and he was arrested. But this case, I'm asking the court, it says here on his conditions of release, to stay away from the police station except in emergency. So Mr. McCullough is concerned that he's trespassed from the police station. I'm advising him he's not, that he doesn't have a term of release anymore once he comes into court, that he has to stay away from the police station. I just want to make it clear that he's never been actually given a trespass notice, but when his bail was set at $400, that was a condition.
That was a condition at the station.
Yes.
By the bail commissioner. Was there a condition imposed on this case here?
I don't think anybody knew about this. It wasn't brought up.
So they're speaking of when I was released and I paid my $400 bail after being in there for almost a weekend. They're speaking about on the bail receipt, there was a comment made by the bail bondsman, which I'm pretty sure was given to him by one of the supervisors in the police station, for me to not come to the police station, because if you guys remember earlier that night, I was recording and they had a whole problem with me. I was recording at that police station, maybe about 4 to 5 hours earlier. And the second time when I came around, that's when Officer Roby arrested me, which was about 2 blocks away from the police station. So they had a hard on for me from earlier, from a few hours earlier. They had a big hard on for me. So I guess the word was passed around. I've already had recorded Roby in the past. He was a second time with me, one-on-one, with my camera on him, recording him, and I guess he had enough. But yeah. So they're speaking about when he wrote on the bail receipt that I was to not come to the police station, which is unconstitutional. He couldn't do that. So she's trying to get that out of there. Yeah, actually, I still have the receipt where it says, "Do not come to the police station unless it's an emergency."
So he just wants to be clear that
Does
he can go
probation
to
have
the
that as a condition of his release?
police station and meeting.
No conditions.
He doesn't have any conditions on this case as far as the docket is concerned.
And he asked me to consider returning his bail money, the $400. I didn't know he had made a bail application.
What's the situation with him? Is he just asking because he's never had a charge before, or because this case has been going on for a while? What's the basis of the request?
He has a
a daughter. She's, how old's your daughter, Ms. McCullough? 5 years old. He's the primary caretaker. He has limited income. He could use the $400 for necessities. I think that the record that I have for Mr. McCullough, is his record in the session?
I have his record right here. What do you?
I thought he was released on personal. I didn't know that they asked for a bail at the station of $400. Otherwise, I would have previously addressed this. Just asking the court if it would consider reducing his bail to personal. He's been here every time without incident. He's never been involved in.
On 10-2, the court said it at first.
So you,
So
Sounds
if
like
it's set, if it's set personal by the court, it looks like the
you can get your $400 back in.
bail was
The clerk's office downstairs any day you want. Get it back. And I have a motion for rescue. Jordan, the court.
20. Was he in default for a while?
Originally, they were going to allow, the Commonwealth stated that they would have dismissed this case. Either prior or after arraignment of 25 hours of community service. It was an issue, so. Today, Mr. McCullough is doing 60 hours of community service for a case downtown. It's supposed to be a global resolution, a certain number of hours. We couldn't come to an agreement. It was continued numerous times to say that this was
Bill said it personal, so.
Thank you.
So a large motion for funds for up to $500. Looks like his bill said it personal, so
I appreciate that.
Bill, I'm not gonna address any motion to reduce. It's already said it personal, so he should be able to get the money back.
I think when Mr. McCullough originally came in, he was gonna represent himself. And then his case got continued to see if could be resolved. And then,
You're gonna minus the 150 though.
and he's been assessed 150.
Yes, he was said 150 attorney fee. So, what date?
I'd like to put out for a Rule 17 date, so.
May 20?
How about June 10th?
I think that date's closed. Do you already have
Is it
some?
closed already?
Yeah, it looks like it's text out here.
Is May 27th open?
May 27th is closed. Motions?
Non-evidentiary,
Non-evidentiary.
Six,
rules. What was that?
June 24th?
June 24
That's available.
for motion. June 24th for motion.
Thank you, Your Honor.
Discovery motions?
Non-evidentiary.
Non-evidentiary.
Six,
rules. Is that it?
All right, Mr. McCullough, motion to dismiss, allow as account
Mr.
3.
McCullough, can you please pay attention to the clerk, sir?
Motion for discovery was
You stand
allowed
up.
and denied. See motion.
Sorry.
Motion to dismiss due to exculpatory video denied. The matter will be
He had to ask me to pay attention to the clerk and stand up because I was discussing what was going on with my public defender. So I wasn't processing what was going on at the end, and the judge had to bring me to attention.
June 24th
That's available.
for motion. June 24th for motion.
Thank you, Your Honor.
Discovery motions?
Non-evidentiary.
Non-evidentiary.
Six,
rules.
seven.
Is that it?
All right, Mr. McCullough, motion to dismiss, allow as to count
Mr.
three.
McCullough, can you please pay attention to the clerk, sir?
Motion for discovery was
You stand
allowed
up.
and denied, see motion.
I'm sorry.
Motion to dismiss due to exculpatory video denied, the matter will be continued June 24th for motions in a sixth session.
Thank you.
Thank you.
Hey man, I would love to go into trial because that's what's next up. I would love to start trial right now, but it wouldn't be a good time to start. What we just heard was all pre-trial hearings. The next audio that I have is trial, so I think I'm going to start that off fresh. This was on April 14th, 2022. Next thing we got coming is October 6th, 2022, and October 7th, 2022. And y'all all know what happened on that day. But October 6th was a full day, and October 7th was only about 3 hours, 3.5 hours at the most. Probably not even that much. And I would love to get into it right now, but it's already late, and I'm feeling a little sleepy, so I don't want to burn out on y'all. And I'm just going to have to wait if y'all want to hear it. And, it'll be a good time to share this. And, I'll be giving y'all updates on when I'm going to play it. What days y'all think I should play it on? Wednesday, Thursday, Friday? Let me know. It's the resistance. Shout out to everybody in the chat, man. The gang's all here. They've been here from the beginning, and they stayed here. Mom's Wholesome Videos. Jack Off Jack. Strictly Business. The Queen, Vanetta Williams. All the way from Wynn, Arkansas. Bill of Rights. Django ATX. Right to Freedom Girl. Appreciate y'all. Kevin Spade. Mark Wunderlich. Can't forget about Cajun Randy 214. Baba Babel. I'll make sure I have a good night. Remember, that audio trial hearing coming up soon. Stay tuned. Might be as early as tomorrow morning. I'll make sure y'all have a good night. I'm out of here. Not guilty. Hit the lights! Everybody about to get killed out here. Like it for everybody. It's the resistance. I'm just a black man with cameras.
It's a very psychological thing that's happening here.